Okay, just one moment. Just making sure it's connected to. Here we go. Yep, you're now live. Okay.
We're live now. Okay, perfect. Thank you.
Right. Bye.
Bye. Okay, I think Kate's struggling to join on camera, but it's fine. Let's start without her.
All right, no worries. Okay, so sorry about that, guys. Had a few technical problems this morning, but we're back now. So we'll just jump back through. So we've just been talking about the legal requirements you need when you're starting up your VA business. So let's just start with the basics. So what are the absolute must-have legal documents a VA needs to have in place when they start working with clients?
Okay, so we would always recommend a contract. It will save you no end. So a contract that is designed around VA work, because obviously you've got various areas that need protecting. There's lots of important points in there. So a contract is number one. You have a legal obligation to have a data processing agreement or a contract with data processing agreement clauses in the actual contract if you're processing personal data. Now, I would say probably 95% of VAs are processing personal data. Obviously, this applies to the UK, I should say, because we're qualified here. So contract, data processing clauses, and an absolute must, we would say, is insurance. Insurance will just help you no end. It will help you sleep at night if anything goes wrong. Obviously, if you're self-employed as opposed to having a company, that insurance is really important, because as a self-employed person, you are that legal entity. So if something goes wrong, they'll come after you, and it will be you that they sue. And if you've got a house, any equity in your house, they can actually tap into that source. So
wow.
But that is essentially what it boils down to. So when it comes to VAs, professional indemnity is the main insurance that you should have here in the UK, and that covers the provision of your services. However, you might want to consider some other insurances depending on what you do. So if you're going out to trade shows, exhibitions, if you're networking, if you're meeting a client in a public space, yes, that public space should have insurance, but you need to insure yourself if you leave a wire line from your laptop and someone trips over it, or you spill a drink on someone or networking. So public liability for that scenario. But if you're always going to work at home and you're never going to go out and do any networking or trade events, then it's just professional indemnity. You may want to think about cyber insurance as well. That's not a legal requirement to have that one, but obviously it makes good business sense if you're, exchanging data that way. So those are the three important elements that you should have. It goes without saying that you need to register with the ICO if you're processing personal data. That's the Information Commissioner's Office. One thing that's a bit unfortunate about the Information Commissioner's Office is the questionnaire that you fill in to find out if you have to register with them is not the most straightforward. So sometimes the questions can be read one of two ways, but we would say 95% of the time, if you're a VA in the United Kingdom, you are going to have to register with the ICO. If you're listening from anywhere else in the world, Europe, for instance, there are the equivalent of the Information Commissioner's Office in your country. So I know Spain has one, France has, can't remember the official names, but, if you data protection regulator in your country, then it would come up there as well.
And is that like a service that you guys could potentially offer to anybody like myself who doesn't understand legal jargon or insurance or ICO applications or anything like that? If VAs out there are unsure about what they were signing up for, or if they had the application form they weren't sure of, is that something that they could come to you and speak to you guys about?
Yeah, absolutely. So we have a range of templates for VA contracts on our website. So if you've purchased a contract from us, we're always open to answering any questions. So you can pop us an email and say, look, I don't know what I need. How would you answer this question? What insurance do you think I need? I'm going to be doing X, Y, and Z. We know that with VAs, it varies. You can get admin, you can get tech. So it is really going to vary, and you're going to have different legal questions that pop up. So shoot us an email, even if you're not a client and you want a little bit of guidance, we're there. We've got a checklist that we can give you, and it really is just a bullet point plan, and that helps you sort of answer some of those questions. But yeah, we're absolutely available. So
that's brilliant. And is there any sort of insurance companies that you would recommend to go to? That, because there's so many out there, isn't there? I was doing an insurance thing for a client yesterday, just to cover tech and laptops and things, and there were so many different things on there. Is there anybody that you would really recommend to go to as an insurance company?
Yeah, so the main one that VAs seem to go to is Policy B, which is part of Hiscox. What I would say when it comes to insurance is don't necessarily go for the cheapest insurance provider.
Yeah.
Do some research, because not all insurance providers are born equal. What you don't want is for something to go wrong and for that insurance company just pick apart everything. And, if they're never going to pay out, it's pointless to have the insurance, and you're going to have a legal argument with your insurance provider. Someone like, Policy B, Hiscox, those more mainstream ones, their helplines are actually really good. So if you think that you should be reporting something because maybe there's been a breach, or maybe your client's pushing for something, they do have really helpful helplines that can guide you through. And whilst they won't take on the issue straight away for you, they will provide you with that guidance. So those are the ones that we hear commonly for VAs, is Policy B and Hiscox. So
yeah, you're absolutely right, because I know that when I did my insurance, because I don't understand it, you just automatically go for the cheapest one, because you're starting out as a business, aren't you? So you're trying to keep all your costs down on all the various platforms and things that you need to use. You do invariably just go, well, it's the cheapest one, it must be okay. So you're right to kind of look into it, and for sure drop you guys an email just to see if you can give a bit of guidance.
Absolutely. And I think that some insurance providers will oversell. So they'll say that you need absolutely everything, and if you're never going to go out and do that networking, I think most VAs probably would, but if you're never going to go out to any trade fairs or networking, you don't need the public liability, and you certainly don't need things like product liability unless you are putting product out there. So
yeah, that's really good advice. I mean, a lot of VAs struggle with scope creep as well, don't they? So like when a client starts adding extra tasks outside of the agreed work, and a client isn't realistic about the time that they have in their support plan, are there any specific clauses you'd recommend including into like the contracts to protect the VAs?
Yeah, absolutely. So all of our VA contracts that we draft, and actually for a lot of industries, we put what's called a time clause in there, which is about the protection of your time. So response times, when you're going to be available, what happens with holiday. Just because you say you're working 9 to 5 doesn't mean you're available to deal with that matter 9 to 5. So it's about setting that out in that clause as well. And obviously we would always recommend a scope creep clause, but a scope creep clause,
hard to say, isn't it?
is only as good as you are. And the reason for that is when you define what you're doing, if you're doing, say, a retainer and you're doing set things each month, you need to carefully define what you're going to do. So don't just put social media. You'd need to put social media. You'd need to put what was it graphics? Was it carousel? Is it reel? Is it stories? What platforms is it going across? Are you engaging? Are you doing hashtag? Put as much detail in there as you possibly can. And then when the client comes to you and says, oh, actually, I thought you were doing such and such, then you can refer back and say, well, actually, the description of the retainer deals with blah, blah, blah. And that's when the scope creep clause will kick in, because you can clearly show that that was outside of what we would call scope. So and ours, we have them in ours as standard.
I mean, that's something that I would have never even thought of putting in a contract. I mean, I think as well, when you're doing a contract, you try not to make it too lengthy and too long. But I suppose what you're saying is the more information you've got, the more covered you are in terms of, the scope, really.
Absolutely, definitely, when it comes to describing the services. And I get that, some VAs will still work on an hourly rate basis, and it really will be an on-call for what you're going to do. And in which case, that's fine, because you just charge your hourly rate for that work. Oh, I think Kate's saying she's in the waiting room.
Oh, okay. Let me
see if she's there.
Here she is. Hello.
Hello, can you hear me? I've had to move to my laptop. My camera wasn't playing ball.
Oh, we've had it all this morning, haven't we?
Haven't we just?
We're just having a chat really about the right documents and insurance and contracts and things. And we were just saying about having the scope creep clause in your contract, because it's, I was saying that I would never have thought of putting in, what platforms you're using and like hashtags and graphics and things like that. But I suppose we were just saying, like, the more information you put into your contract, the more you're covered on. So it's a bit, what's the word, kind of off-putting when you're doing a contract, because you don't want to have pages and pages and pages and pages. But actually, what you guys say is put as much in there as possible to cover you for everything that you're doing.
Yeah, and there's no room for anybody to argue then for your client to come back and say, well, I didn't think that was included, or I thought that was included.
Yeah.
Or it's a good way of putting things in that you're not going to do as well, not just things you are going to do. If you're really not comfortable with doing something that's perhaps associated to the services you are offering, then put it in the contract, and then the client can't come back to you and say, well, I thought you could do that. So yeah, absolutely.
And I do think you almost need to get away from the mindset of thinking, oh, the contract is too long, the contract is too long. The contract is there to protect you, and it's there to protect your client as well. Now, I'm not saying make it a 50-page contract, because that would be completely out of scope. But to define your services, just think of it as like a proposal or a scope of work, and it's that's being attached to the contract. So don't worry about putting too much information in there. Really, any client that's worth the salt will understand that it's designed to protect them as well. It's not just a one-sided scenario. Obviously, it's going to be more weighted to you in terms of legalities, but it's also there to protect them and set clear boundaries. So.
And that's what we say. I mean, we say to our clients, it's a client contract to protect you and to protect us. It's, it kind of goes both ways. And you're right that, any client that's worth their salt will be happy to sign any contract that you put to them. But I think we touched on this last week, that a lot of VAs, particularly when you're starting out, don't feel like they can sort of say that to clients, like, well, it's, this is your contract and we didn't agree that. And it's about finding that voice, isn't it? And being able to challenge them. If they ask you to do something that's not in the contract or the scope of work, it's difficult to say, we didn't agree that, because you don't want to upset that client, particularly if you're new. So it's hard to find a voice sometimes.
It definitely is. Yeah. And I think it's coming away from the mentality of being an employee and having to do absolutely everything. Essentially, you are now the owner of your business. And, probably one of the reasons that you're an owner of your own business is because you want the ability to say no. So, I know it's easy for me to say, find your voice from day one. It's not, I get that it's not as simple as that, but putting in place solid practices from day one will save heartache later. Things that, even us as lawyers wish we had done differently. There were some initial clients that we gave our personal WhatsApp number to, and now they think it's appropriate to text at 10 o'clock at night on a Friday evening when you've switched off. So, even we learn from those types of mistakes. So clear boundaries from day one will absolutely save you in terms of stress later, without a doubt.
I mean, another thing we've touched on previously is late payments. So late payments are a classic freelancer issue, although we do encourage all VAs to charge up front, which we do with all of our clients. How can a VA set up a contract to ensure better protection and faster payment?
Well, as you've mentioned, getting payment up front, or as much as you possibly can. So it's something we always discuss with clients anyway, is obviously the payment terms they want to put in their contract. And if you're new in business, then sometimes it is easier to please the client and do the payment after the work is completed, or payment at the end of the month. But that is absolutely not a reason for not putting in strict payment terms from the beginning. So having either a proportion up front, or if you're working on a retainer, then the traditional retainer model is payment before the work is done. That was always what the tradition was for a retainer. And I think somehow over the years it's become a bit muddied the waters a bit in terms of what a retainer actually is. So if you're working on a retainer, then there is nothing wrong with asking for the money up front for that month's work, for that amount of hours that you're doing, before you even start doing the work. So before the first of the month, payments there in your bank, so that you know that the work you're doing, you've already been paid for. And again, that should then follow on month on month on month. If you're working a little bit differently in terms of, say, a package, again, that should be upfront as well. Or if you're not comfortable, or the client's not comfortable in doing that, then you can split it. So you can have 50-50, or you can set milestones throughout the month, so that you if you're doing 20 hours, for instance, you get paid once you've done 5 hours, once you've done 10 hours, once you've done 15 hours, and then it's really easy to keep track of it and stop work if you haven't been paid for that proportion that you're expecting payment for. So there's lots of different ways of doing it. Having the right clauses in the contract is obviously really important. Making sure that your payment terms in the contract do reflect accurately what you've spoken to the client and agreed with the client. And having a late payment clause as well, and a pause work clause in there to protect you if you haven't been paid. Stop down tools and do it as soon as you possibly can. It's really easy to get into a trap of being too flexible with clients. And just trying to, they've said, we'll pay you in a few weeks, to just continue with those few weeks. But that's a really dangerous trap to fall into, because you've only got their word, and especially if it's a new relationship and you haven't built up that trust yet, then it's quite dangerous to do that. It should be, stick to your terms, stick to what you've agreed. If you set down tools, you'll soon find the payment will come through quite quickly if there's no work coming through for the client and they're working to a deadline or it's a project that needs to be completed. So it's about just making sure that you're strict, you've got the right clauses in your contract to back it up, your payment terms reflect what you've agreed, and then hopefully you shouldn't, there's always going to be issues, inevitable, but minimizing those issues is definitely important from the start.
It's definitely about how you manage it as well. So if you, for instance, if you are taking payment after the event, then set up a clear process of doing that. So if you're using software like QuickBooks, Xero, whatever, have a payment reminder go out on the day that if it wasn't paid, so an auto trigger to go out chasing that, and then follow a next step of, if that hasn't triggered payment a week later, then pick up the phone. Lots of people are afraid to pick up the phone. He or they who shout loudest is more likely the first to be paid. It is as simple as that. But don't, be strict and follow that strict process every time, because if you give someone an inch, they'll think they've got that for the whole period of time. So it's about, I know sometimes you just have to psych yourself up and make that call, but force yourself to do it. And I promise you, if it's something that you're doing regularly, you'll grow more confidence in doing it. And 9 times out of 10, people will be embarrassed to speak to you on the phone. They just pay you next month on time, and you won't have to deal with it.
An email's so easy to ignore and just reply to, whereas a phone call, people can't avoid you once you've got them on the end of the phone. They have to do some sort of response.
I mean, it's hard, isn't it? I mean, what would your advice be to somebody that has tried every avenue of kind of being able to get that payment? What would be the next step? So if you've kind of phoned and emailed and messaged and all that kind of thing, you can't get hold of that client, you've down tools, but you're still owed a significant amount of money, or a small amount of money, whatever the value will be, what would your advice be to the next steps?
So if you've done all the warning letters, the trigger letters saying, look, this money needs to come in, if it's not coming in, and then you would shoot them a final warner and say, look, if this is not in by this time of day on this date, I'm going to issue legal proceedings. Don't be afraid of legal proceedings. Everyone thinks that it's like massively scary, but if you're, I don't know, say you're 6 or 7 grand, Money Claims Online is designed for the average person. I promise you, you log on to Money Claims Online, create an account, and it really is a step-by-step process. The system is designed to just ask you a series of questions and you answer it, and then it will generate the form and it will auto go out. So 9 times out of 10, when someone receives a claim form, they'll and make payment in that regard, and they're liable for the court fee as well. That's obviously a small claims court.
Okay.
Obviously, you don't get paid your time in the small claims court, unfortunately, so you won't recover any legal costs in the small claims court other than the court fee that you've paid to issue. If it's, I think it's 10,000 now, isn't it? Over 10,000, it wouldn't count as a small claims. It would go to the multi-track.
Multi-track,
and it would just be dealt with in terms of, you could potentially get your costs if there was anything unreasonable there. There needs to be a justification as to why you're not paying an invoice. If you've issued the invoice and you can stand there and say, I legitimately have done this work, then proceed. issue to court. You know, the clients are always going to have, it's like that age-old story, isn't it? The dog ate my homework. There's always going to be an excuse for someone that they're just that way inclined. Unless they can justify it, the court aren't going to award in their favour. So, you know, legal proceedings aren't as scary as you think it is. If you've done everything right, so you've got a clear-cut contract in place and you've defined when payment is due, your invoice has the due date on it, and you've followed that proper process every single time, you should have the confidence to be able to issue. And I know that's easy for me to say because I'm a lawyer, but I promise you it's set up, especially the money claims online.
Yeah, it's
set up
a really easy
for most people to
process.
do
Yeah.
it.
And another tip is to actually, once you've completed the claim form, save it in draft, download a copy, email it to the client and say, listen, next step is this is being issued. I'm going to press that button and issue this to the courts unless I receive payment in the next 24 hours, 2 days, whatever. Don't be too flexible in terms of timing at that point. You need to make it an urgent request that, you know, if the payment isn't forthcoming in full, then that's what's going to happen next.
And invariably somebody receiving something like that would, you know, put the fear of God into somebody, wouldn't it? So you would automatically think, I've got to pay this. And, you know, I think they would hope to think that they would pay on time if you choose to work with them again, of course. I mean, it's a sketchy line, isn't it? But I
always say if someone's put you to that much trouble, it's not worth it. And I think a lot of people need to listen to their red flags. Alerts going off, because honestly, I swear to you, 9 times out of 10, if you have a funny feeling about something, 9 times out of 10 you're correct. So if you're unnerved and you know that this client is going to be a tricky client, or they're going to push the boundaries, or they're not going to pay you, listen to yourself. Honestly, you'll save so much heartache. And, you know, personally, if I had to sue someone to get paid, never work with them again.
No,
it's not worth
it.
The
relationship to, you know, you can't repair it after that, something like that.
Yeah, I mean, I personally haven't, you know, with kind of late payers. And I think as well, because we're virtual assistants, your client isn't just around the corner, are they? Sometimes they can potentially be in another country, so you can't just get in your car and drive around the door. So it's quite hard. So it's good to have that knowledge in place, that don't be scared to kind of stand up for yourself, ask for your payment, and, you know, come to you guys if you need some legal help. And, you know, if you're struggling to get a payment, then we're always on hand to offer advice and help you through it. So do give us a shout if we can help with anything. What advice can you offer when clients ask freelancers to sign an NDA? What should we be looking out for? Are there any clauses like non-competes or non-solicitation? That's the right word. Actually enforceable in the UK, or are they more of a polite deterrent?
So an NDA is something that should only be used in a pre-contract stage of a relationship. So normally, if you're issuing an NDA, it's because you're talking to another party and you want to protect confidential information. That is an NDA's purpose. Once you've gone beyond that stage and you're going to work with somebody, then your client contract or your client T's and C's should then kick in, and that should have the correct clause in it that protects confidentiality and everything else. So you shouldn't really be working under a contract and an NDA, because what you want to avoid is those two agreements conflicting with each other.
Yeah.
So if a client's asking you to sign, you know, if you're asking a client to sign your client contract and the client's wanting you to sign an NDA, you shouldn't be doing that. You should go to the client and say, listen, my contract includes all the clauses you need in relation to confidentiality, non-solicitation. So that's sufficient. As I said, an NDA is really only used, it's used for lots of different reasons, but when there isn't a contract in place that can protect you. If you've got an NDA that has non-compete in it, then that would be big alarm bells for me if I was asked to sign it, because an NDA, the true purpose of an NDA is just to protect confidential, sensitive information that you're sharing, whether both parties are sharing it or just one party. And non-compete has no place in an NDA as far as I'm concerned from a legal perspective.
But we've also actually seen an intellectual property clause snuck into an NDA recently as well, which was really naughty. So it was basically transferring the knowledge base automatically to the client, and that wasn't the purpose of the agreement. The NDA is confidentiality. It's as simple as that, and that you're not going to use any of their, client materials, let's call it, to then, circumvent them and go and do it, using their information. So that's the point of an NDA. What I would say is, although we've said, really everything should be in your client contract, there are some clients that still feel comfortable and feel better about having an NDA. So sometimes it's lack of knowledge. So I think some people don't realise that actually it's a pre-contractual document. And I think that's where you get some clients saying, well, actually, I want the protection of an NDA. If you get to that, you just need to check that there's nothing that's conflicting in your client contract. And, if in doubt, ask someone legally minded to review that NDA for you to make sure there isn't conflicting. Because what used to happen was the last contract signed was the one that took precedence. So that's the contract that you're working with. But there's been case law that's completely got rid of that and gone the other way, and it's been held the other way. So then you've got an argument as to whose contract prevails. Does the NDA take precedent over the contract? So make sure it's reviewed first. Just to,
that's the pitfalls generally with NDAs are they can either be really broad in scope, so that means they become less effective, or they're very, very narrow in scope, which means you can't really do your job because of the requirements under the NDA being too narrow. So it's quite, some people think an NDA is just a generic document. It really isn't. It does need to be quite thought out in terms of the work you're doing under the NDA, the information you're sharing under the NDA, and as I said, the narrow or broadness of the clause wording in the document itself. So
I suppose that would also go with if your client then asks you to sign their agreement. It's the same, isn't it? So it would almost
don't ever do that.
Don't ever sign.
No, really don't.
No, that's a really big no. For the reason
big red flag
out is that conflicting information in each client in each contract, and also essentially it used to be, as Kirsty said, that the last one signed would prevail, would govern the relationship, but now case law has completely knocked that on its head. So it's a very messy situation to get into, and definitely avoid it.
Never sign two is essentially the answer there. We would always advocate to use your client contract. It's your VA contract. You're always going to advocate for that. But you do have some companies like local authorities, government agencies just simply won't sign your contract and they'll issue theirs. And if that is the case, then you need to get that contract checked, because there are some quite unscrupulous large corporations that sneak some things in. So always push for your VA contract. If someone's asking you to sign theirs, it's one contract, it's their contract or your contract, and get that contract checked. If you're not confident that there isn't anything niggly in there that could, really affect you, don't sign it. Get advice. The amount of disputes we've had because someone signed a contract and not read it, and then trying to deal with it afterwards is just an absolute nightmare. So be sure what you're signing, essentially.
It's a difficult one again, isn't it? Because I do try to read through things, and thankfully Lisa handles all that kind of side of it. So, but people generally don't sort of. I think they're afraid to ask questions. So, if a client was to ask us to sign their agreement, does that not make us an employee?
No.
It would depend on the terminology. It just means that, you can still be a freelancer or a subcontractor, but it's important what the clauses say. So don't be treated like an employee. So these clauses like non-compete has absolutely no place in the VA world as far as I'm concerned. You're not an employee, you're a contractor, and the chances are you're probably going to work with similar businesses, because that's how niches tend to work.
Into working with coaches, for instance, then a non-compete in the contract is essentially meaning you can't work with any other coaches. So it's
so definitely.
Well, that's a bit of a scary area, that one, isn't it?
It definitely is, and like I say, people do sneak in those clauses, but it honestly has no place in the VA market as far as I'm concerned.
Non-solicitation, yes, but non-compete, no. Non-compete generally is for an employment relationship, employee.
And there is a difference between non-compete and non-solicitation. So non-compete is you can't work with a competitor, so another coach. Non-solicitation is that you won't poach their clients.
Right. Okay.
So non-solicitation's fine, because I think it's reasonable that you wouldn't go after your client's clients. Absolutely reasonable. You're using that information to your advantage when you shouldn't be. Non-solicitation, as long as it's limited to a certain period of time, fine.
Yeah.
Non-compete, no.
Yeah, because I know that some people do put into, when you put on garden leave, you can't then approach clients of the same industry for like 6 months or something like that, and then it's.
And again, garden leave should not feature in a genuine VA relationship. It's an employee term, and if someone's trying to get it into a VA contract, absolutely no.
Absolutely not.
Definitely.
And from a legal standpoint, should a VA operate as a sole trader or a limited company? Now, I have no idea about this, so this advice is great for me because I'm not limited, so I don't know what the difference is, what the benefits are.
It's a good question, and it's one we get asked an awful lot. So you can be either. There's no, there's no rule, no law to say you should be one or the other. It's down to preference. From a legal perspective, then we would always say limited company will protect you more, and that is because you've got that limited liability. And what that means is, when you're a sole trader, you are the business, so there's no separation between you and the business. So if something goes wrong and a client wants to sue you for something you've done, then hopefully your insurance, if you've got it, will protect you, but that's not always the case. And it means that all your personal assets are at risk. If a client sues you for a large sum of money, it means your house, anything you own, you could be at risk of losing it. Whereas with a limited company, you've got what's called limited liability, and that means that the business is a separate legal entity. So the business is separate to you because you're a shareholder and a director of the company, can be an employee of the company as well, but it's separate. So anything that happens and somebody sues the company's liable, not you personally. So obviously an accountant will say differently, and there are obviously lots to consider between the two, because there's different tax efficiencies of being a sole trader over a limited company up to a certain turnover and all sorts of other things. But actually, from a legal perspective, for us, limited company, definitely.
Sorry, go on.
I was going to say, that's not to say don't, if you're a sole trader, don't immediately start to go into panic, because there are a lot of people that practice as a sole trader, but it always comes down to risk. So if you're doing, something that's minimal risk, you're just doing the odd, newsletter here and there, and you're not going to, massively affect something. Whereas if you're a tech VA and you take down their whole entire system and no one can order from their website or something, and you take down their whole revenue for months on end because of something you did, obviously that's a greater risk, and that's the type of scenario that we'd say, move on to a limited company. Also have a decent clause in your contract, but take that aside. So judgment with risk. So obviously we're always going to say limited company because you have that protection, but we understand that it's a balance of risk for people on the ground in terms of deciding which methods or which option is best for them.
And if you're just a one-person business, then that's less risk because it's just you. You're the only person doing that work. You can control everything in your business because you're the only one doing it. Once you start to take on maybe associates or working with other people, maybe to provide services, that's when obviously that net widens and the risk is heightened. So it might be something like that triggers you to move from a sole trader to a limited company, because you haven't got that ultimate control that you had when it was just you.
And is it relatively easy to do that? Because I wouldn't even know where to start looking to go to be a limited. Do you just put limited on the end of your business name, or
No, you would actually need to register with Companies House. So you'd need to formally set up a limited company with Companies House. Usually speaking, an accountant would do that for you. You can do it yourself, but I would say it's easier to have an accountant do that for you. And then you've got to think about what happens with that. So if you've got any contracts in your sole trader's name, you need to, essentially reissue them in the limited company name and end the old contracts. You need to think about updating, like your website, your insurance and everything like that. It's not that hard to do. it is a lot of admin, but that's what you excel at as VAs, is admin. So it's probably going to be a walk in the park in terms of all of those bits that need updating for you. But yeah, I'd say, you know, have an accountant register as a limited company for you.
And then they can talk you through all the additional things that come with being limited compared to sole trader, because you've obviously got obligations then to file certain things at certain times with Companies House. So just having an awareness of that is always good as well.
Well, that's something I'll definitely look into then. Thank you.
Yeah, to give you that protection.
Absolutely, yeah, because it does reassure you, doesn't it? You know, it's just when you don't understand that side of it, but actually it's you know, it's reassurance, isn't it, as well? What are some of the most common legal mistakes you see freelance and VAs making, especially when transitioning to agency style businesses?
Lately, honestly, it's the contracts that they've signed. Unfortunately, we'd like to think that everyone has some nice contracts in place and they're there to protect both parties. But a common mistake when someone, goes to work as an associate or an agency is signing the contract and not reading it. We have seen some devastating contracts lately that people just haven't realised what they've done. They're never going to get paid, or it's a case of you're only going to get paid when they're paid, and that's traditionally not the model of an associate. You've done the work, you're entitled to be paid. The fact that the client hasn't paid them has nothing to do with you. You don't have a legal relationship with that client. The chain isn't there. So delays in payment, giving away intellectual property when they shouldn't. Never have a clause in a contract that gives all of your intellectual property away, because you're giving everything away. Your processes, your methodologies, your templates, everything that you might need with another client. There's some awful contracts that people are using and giving everything away. Can't use it again. So I think those are the main two, aren't they? The intellectual property.
And another one is the termination clause. Read that very carefully. Yes. We've seen some contracts that don't even have the ability for you to terminate as the as the other party. Sometimes there's no ability for either party to terminate, which is absolute madness from a perspective. So definitely check the wording there to make sure you understand how you can end the contract if you want to.
Oh, that's terrifying, isn't it? What a terrible situation to be in. How would you ever resolve something like that? You just...
I mean, obviously, if mutually you both want to get out of the contract, that's fine. It has to be a mutual thing and you walk away. Absolutely.
Yeah.
No. But if one party's in disagreement, that's where there's a big issue.
And they're not going to argue it legally, unfortunately. And, people think that when you go to a lawyer, they can tell you yes or no. But when it's in scenarios of things like that you didn't think of something, then you have to look at what the parties had in mind. And, was there background information? Was someone told something beforehand? Is there email communication? And it has to be judged on who is more believable. So it's never a yes or no scenario in that type of question. So, people come to us and say, quick question. Never a quick question. It's never, because you've got to look at the background. You've got to look at the history. What was in the minds of the party? What's led to the not wanting to work together? Is it because someone's breached because they've, used their intellectual property, or if they, breached in terms of leaking confidential information? It's never a yes or no answer. So that's why it's important to get those contracts right from the start, and that termination clause will help you no end. How lovely is it to say, I've decided that this isn't working, and in accordance with such and such, we're just going to give each other 14 days notice and part our ways, and we're just going to walk off into the sunset and it's going to be fine. You don't have that clause in there, and you've got to prove a breach. You've got to be insolvent, or something else that requires an action, an approvable action. You're going to argue about. So
And also as well, like GDPR can feel like a legal minefield. What are the key data protection responsibilities for a VA handling client information and systems?
Okay, so I'm not going to go into too much detail because I could talk for hours about data, as Kirsty knows. Registration with the ICO is a must. If you're a VA, you have to register with the ICO, and I don't care what anybody else out there says that they've answered the questions on the ICO self-checker. As a VA, you are dealing with personal data for your client and in your own business, and you're dealing with it electronically. And that, to me, is there shouldn't be any other questions you need to ask yourself or answer. Is that means you've got to register with the ICO. I think Kirsty mentioned earlier about the ICO checker, and it, as good as the answers you give it, and sometimes it can give you a result of no, you don't need to, but you do as a VA. There's no getting out of it. So ICO registration, having a contract that has data processing clauses in it, because you are going to be processing data on behalf of your clients. And if you don't have those in your contract or your terms and conditions, then you have to have a separate data processing agreement. That's a legal requirement. If you've got a website, you need to have a privacy policy on it. Actually, now the guidance from the ICO coming through is if you're dealing with data electronically, regardless of whether you've got a website, you should have a privacy policy on there. And then just making sure you're handling the data using common sense. So it doesn't have to be complicated. If you're a small business and you're just, doing, you've got a handful of clients and you're just doing, standard VA services, it doesn't have to be complicated. Just make sure you're using password protection. You aren't going into a cafe down the road and logging onto their public Wi-Fi and doing work. You're using a VPN if you can. It's not it's not a legal requirement. The only thing the legislation says is you need to use, process the data in a secure and safe way. So it just means common sense, password protection, not leaving your mobile phone unlocked on a train and going to the toilet while it's sat on your chair. You wouldn't do that anyway, but not bringing your neighbour around for a cup of coffee and leaving your laptop open with your client's data on it. It's just practical common sense approach for complying with GDPR.
And I think a really good way to think about it is think about how you would like your data to be treated. What would you do to protect your personal data? You wouldn't just email a copy of your passport to someone. You'd put a password on it and you'd send it by a different method. You wouldn't put public information into a forum that other people can access. So treat people's data in the most sensitive way possible and how you would like to be treated as well. I mean, obviously we all have different perceptions, but go above and beyond. We're probably more alert and aware of it than others are, but that's your job. You've taken on that role, you need to protect. So
and another thing I will quickly say is obviously the use of AI. A lot of us out there now are using AI in our business to help with whatever. Do not ever put any personal data into any AI software at all, because it's not safe, it's not secure. So you are already breaching that obligation if you do that. So it's
again, it's another one of those confusing things, isn't it, of understanding and making sure that you're ticking all the boxes and making sure that you're covered. And so it's great advice from you guys. So you offer downloadable templates, which is brilliant, but how can a VA tell when a DIY legal document is enough versus when they really need a bespoke contract?
Honestly, I would always say that a template document that is drafted for your industry, I would say you should assume that is going to protect you. I can't tell you that every VA template out there is going to protect you. I've seen some diabolical ones out there. Obviously, ours is great. We're obviously going to say that. It's written by us. But I'm a former litigator, so I've been the person that argues in court. So we think outside of the box and we make sure that we've covered you. We've worked as VAs before whilst we were pregnant, so we understand the industry. Our contracts are drafted with that in mind, and we regularly speak to VAs. So for instance, if a VA comes to us and says, this new scenario has come up, and we say, do you know what, that's a really good one, and we add to our contracts. Just because we've written our contract, it doesn't mean that it's going to stay there. So if a new piece of legislation emerges, if a VA's discovered something absolutely amazing that was never there before and it needs a clause in the contract, that is something that we would add. So you don't necessarily have to have a bespoke contract, but you do have to have an industry specific contract. What is a big no-no is please don't go out there and copy and paste from loads of contracts and try and make your own, because they don't read right for a start. You could be breaching someone else's intellectual property rights, because when someone puts that out there, it's a license to look at it, not a assignment giving it to you. And there are some people, non-lawyers, that have drafted contracts and think that they know a lot more than they do, and they don't. They absolutely don't.
Wow.
So choose wisely. Don't copy and paste. Don't copy
Mm.
something together. Get advice. You really do need a lawyer contract. You really do, to protect
And
you.
don't use AI either. I don't keep
Oh,
harping on
don't use
about AI.
AI.
But I
Oh
saw
my
somebody
goodness.
do it the other day and they sent it to me, and AI is great if you know what you're doing in the background. So, from our perspective, we've seen some AI created policies, some AI created contracts, and they're only as good as the information you put into them. And if you're not understanding, you're not experienced in the information you're putting into it, you're only going to get out what you've put into it. So yeah, it's a bit scary, some of the ones I've seen that somebody said, oh, can you just check this? I created it using GPT.
ChatGPT.
Yeah, and I've looked at it and I'm like, well, it's not got any consumer rights in it. It's not got this. It's not got that. It's no data protection. That's because they didn't know they had to put that in there. So they haven't fed that information into the AI. So yeah.
And one thing I would say is, if you're going to pay us to review something that you've put into ChatGPT, you're probably paying more than you would have paid us for a contract anyway.
Yeah.
So you're actually spending more money getting someone to check something that you've tried to write yourself than you have
spend
to
all the time writing it yourself as well.
Yeah, exactly. So, and the reason for that is it's really hard to review someone else's contract, especially when it's all over the place and focus correctly. And we've seen people pull in US legislation that's completely irrelevant. And honestly, the systems between the US and the UK
So different.
Yeah, it's so massively different. They're obviously more litigation heavy. We've got a lot more restrictions on what you can and can't do. So yeah, it can be detrimental, shall we say.
It's a good point actually about the cut and pasting, because I think as well, if you're somebody like me, if you're cutting and pasting, you think that looks great, but actually you might be conflicting again, like we spoke earlier about NDAs and contracts and things like that. So you may be kind of putting one thing in and then cancelling it out later on down the contract. So you're right, it's good to actually get a legal contract in place. But thank you so much for staying. It's been so nice. I'm so sorry about the technical issues.
Oh, that's okay.
I seriously shouldn't be left alone with links and Instagram and things like that. But if you're listening VAs out there and you want to get your legal house in order, check out kkbservices.com for templates, contracts, and super friendly expert advice. Thank you so much. It's been so good to chat to you. Thank you so much for your advice. It's been brilliant.
Thank you. No worries. Lovely talking to you.
Take care. See you soon.
Bye-bye.